Yep. It's a great way to start it off. It's a great way to start it off. Yeah. I scrolled to the top of the chat, so I didn't see you guys telling me I was muted. I'm not still muted. I can see it. Phil, I just said something really nice about you, too. All right. I just scrolled to the top of the chat and said hi to everyone that's been here. And so I didn't see you guys tell me I was muted. Phil, I said thank you for your nice comment on today's video. I appreciate it. And I said hi to everybody. So now I'm not going to do it again. I'm not going to do it again. But I will do what's going on. I think my voice just cracked a little bit. But yes, Irish Demon Tech. Yep. All right. You guys want to watch some court? Let's watch some court. First clip, Judge Gauthier, I think. Yeah, Judge Gauthier. The clip on the thumbnail is going to be the last clip, and it's a good one. And I just saved it for last, but it's a really good one. It's a really good one. But yeah, let's go. Oh, before we get started, I got to do it. Well, first, like and subscribe if you haven't. Second, I need to share my link tree because I was demonetized. Mimi, we're about to watch some court. All right. I shared that. Now I got to actually open the stream and grab it and pick it. Where'd it go? There we go. How my comment comes in delayed? All right. We're back. Sorry about that. I should have been ready for that. I wasn't. James, welcome. Thank you for telling everyone to hit the like button. All right. Yes. Link tree. If you want to. You don't have to, but it's there. Demonetization Fund. It's a good time. All right. Now.
All right, good morning. We are on the record in the 53rd Circuit Court for the County of Presqu'île. We are providing public access both in the courtroom and also online. And first matter this morning is an arraignment in People versus Joseph and Mazanine.
Thanks, Mimi.
Oh, good morning. Are you Mr. Wise?
He is, and I'm Mr. Funk as counsel.
Okay. Good morning, Mr. Funk.
Good morning, sir.
All right. Well, let's go ahead and call that case. That's from page 3, People versus Joshua Wise, 23-3252 FH. And
we're over. How do we know that? Well, this all the way back to Terry.
Apparently, I still can't.
Yeah, obviously, if we get the report before then, we'll convene the hearing.
At least my head's kind of blocking.
We could call People versus Kyle Knott, file 23-93254 FH. And looks like this is here for a docket call, motion to quash, looks like a show cause to handle as well. Probably just in terms of logical progression, let's start out with your motion to quash. I did review your motion and brief and the prosecutor's response, and I did review the transcript of
Happy
the
birthday
exam. So, Mr. Voida, go ahead and argue the motion.
Thank you, Your Honor. And given the fact that the court has reviewed my brief, I'm not intending to regurgitate that at this point. The issue here is one of obstruction. And you have to decide, in deciding an obstruction issue, whether there was a knowing failure to comply with a lawful command. Now, there are two elements there, lawful command and knowing failure. And I'm going to take those in reverse order and start with the lawful command issue. And that takes us all the way back to Terry v. Ohio. Was there a reasonably articulable suspicion of criminal activity? And the court looks at the totality of the circumstances in making that decision. Here, police officers saw a truck with 2 people inside leave the Nighthawk bar around 3 o'clock in the morning. Stopped briefly in the roadway, then pulled ahead and backed into a nearby driveway. 2 occupants got out and ran into the woods. Now, at that point, when they ran into the woods, there was no stop, there was no command, no lights, no sirens, no detention.
Agreed. So my first question to you is, what do you believe that a reasonable officer should do when faced with that situation? Is it your position that they should say, oh, that's odd, and drive off?
I guess
Or do they have a reasonable suspicion to investigate that unusual suspicious behavior to see what's going on here?
but it has to be suspicious, reasonably suspicious behavior that's attributable to criminal behavior.
Right, but it doesn't have to be, because this often comes up, and attorneys try to tie that to like a specific crime.
Mhm.
So a police officer doesn't have to have reasonable articulable suspicion that you have violated section whatever of whatever code. They just have to have some articulable suspicion that criminal activity is afoot, right?
Right.
So the U.S. Supreme Court case, Illinois v. Wardlow in 2000, said a suspect in a suspicious situation there, it was being in a high crime area, coupled with his flight from nearby police, gave the police reasonable suspicion to justify an investigatory stop. Why wouldn't Illinois v. Wardlow control it here?
Because we simply have running into the woods as the factor. There's not that high crime area. What we have is two people in a vehicle late at night to get out and leave. There's not an additional factor there. And so I think if you were in a situation, and if you wanted to add another factor, it might be driving away from a bar in the early morning hours. Well, okay, that gives reasonable suspicion of potential operating while intoxicated. And there I go trying to tie it to a specific offense. But I can't think of any other offense that might be in play here, other criminal activity that might be in play here. And so if we're talking about something like an OWI, that certainly would give suspicion as to the driver, but not as to the passenger. I don't see any other factors that point toward criminality that would point towards someone that's a passenger under the circumstances that are present in this case. That's where I struggle, Judge. And to be clear, the people seem to concede that point. They say in their argument the officers that evening had more than sufficient cause to at least make inquiry of the driver of the white Dodge. Well, okay, but my client wasn't the driver. How do we know that? Well, car wasn't registered to him. They didn't find keys on him. And here's what's more important. Once the officers track him down and detain him, there's nothing in the record to suggest that they did any sort of OWI investigation. They took his PBT at the jail when they booked him, and they found out that he was drunk. But there were no field sobriety tests, no roadside PBT, no data master, no OWI arrest. And if you look at the information, there's no OWI charged. Nobody thought he was actually driving this vehicle.
One thing that wasn't clear from the transcript, and I don't know if it's on the record, and I just didn't catch it, was the other occupant of the car ever caught or identified?
No.
Oh,
Nor charged.
but they did see 2 people leave the car.
Correct.
So we caught one, but one got away and they don't know who it is.
Right.
Okay. They might think they know, but okay.
Right.
Okay. Continue.
At any rate, it's my position that one factor, suspicious running into the woods, was not enough to meet that standard that the Supreme Court articulated. If you had additional factors, those additional factors would have to be relevant to my client, who is the passenger of the vehicle, and I don't think there are any such factors present. But even assuming that you get past the lawful command stage, there has to be some evidence that it was knowingly disobeyed, that lawful command was knowingly disobeyed. And I go through in my brief a lot of factors at play here. But as you read through the transcript, the officer describes the person running or people running, because he couldn't say who he was specifically chasing, as having crashed through the woods. Now that carries with it a certain volume, and it's not quiet. The person who's crashing through the woods is striking things, stepping on things, making noises that might make it hard to hear.
All right. I'm trying to pause it less. So I'm gonna bear with me. I'm still gonna pause it. I have to. The comment that I highlighted a little bit ago, Biggin played this about a month ago. This is a little old. I had it and I was making a video with it when Biggin put it out. So I just held on to it. It's still a clip. So I just decided to use it on a live instead of in a premiere, but it's a good clip. But why else would he be crashing through the woods? I don't want to give too much away because I've seen this a few times and I don't know if they've already explained what actually happened. Because I don't think the prosecutors talked. The judge hasn't really talked. It's just been the defense so far. So I'm not going to say too much. Not yet. But this story just gets, yeah. All right, let's go.
Most cases that I see for resisting and obstructing, there's a clear understanding of a command. The lights, the police lights are on, the sirens are on. The person responds to an officer who says stop. There's eye contact between the officer and the defendant, and then the defendant runs away. There's physical resistance of some sort, not complying with handcuffs or something along those lines. Of a command, we possess.
Hey, Linda.
We pose to the court that it's not a lawful
Howdy.
command, but if you decide that it is, it's a lawful command. And we don't have any evidence that my client heard the details of that command and knowingly disobeyed them. There's just nothing on the record to suggest that.
Well, I mean, aren't I supposed to, on a probable cause standard, make reasonable inferences from those facts? So your client admitted to the police that he knew that he was being chased and he heard the yelling and the flashlights, and he said he was being hunted like a deer. Is that enough to infer, to let the jury sort this out? I mean, I'll admit to you, this R&O charge seems like a fairly thin read. As I kept reading the transcript, I kept thinking, okay, and then what? And then what? And like I'm expecting they're going to find drugs on him or something, but nothing. So they don't find any contraband. There's no criminal activity that he's charged with other than the mere running. And I got to admit, when I read it, I felt a little deflated at the end. Like, that's it. But on my review of the bind-over decision, I have to find that there's an abuse of discretion. And that aren't these enough facts to draw an inference that he heard the police tell him to stop and he didn't stop?
I don't know if it's enough. He certainly can. You don't even need to draw an inference that he heard someone yelling. I don't think there's enough here to say that he could distinguish what was being yelled, because there's no evidence that he responded in any way. If the officer had observed him to pause after hearing it and then continue to run or something like that, I think we'd be at a point where you could draw that inference. We're operating in the dark in more ways than one of them very literal in this case. And I agree with you that it's a thin read. I think it falls on the abuse of discretion, too thin to proceed to a jury read.
Okay.
But that's where we're at, unless you have any other questions.
Okay, no, thank you, Mr. Rance, find your response.
Judge, I laid out my argument in my brief. I appreciate the court reading everything. But I think if you look at the overall facts of the situation, you're 3 in the morning, car pulls out of the bar parking lot at 3 in the morning. When the deputies turn around and go down the street that the car is on, the car stops right in the middle of the lane of traffic. And I know it's thin, but clearly that's impeding traffic, number one. When the deputies start pulling closer, the car turns around and goes on a side street that comes in on that road at an angle, then backs up over a snowbank and into the driveway. The argument here is that The area was lit by a street light and a light from the bar house. They're gonna mark the toll vehicle. Deputy McClellan states on his testimony that when their car is stopped by yet another person who wants to come up and talk to the driver, they're close enough with the side.
That's definitely
view,
what he was doing.
anybody in the
There's
truck
pine
could have
trees.
seen it was a
High pick.
police vehicle. Then they notice someone from the driver's side get out in a hurry, almost fall down, and then take off running. I don't think it was clear that they ever saw the second person run from the vehicle, although he does see two tracks in the woods. He testifies that he's anywhere from 50 yards in the woods to at some point even closer, yelling in a loud outdoor voice numerous times to stop.
They're supposed to be in bed.
There's an argument here certainly to be made. It may be circumstantial, but there's certainly an argument, a reasonable inference to be drawn from those facts. And the person continues to run and evade the police until he's finally caught by another officer. So we think there's enough for.
Okay, thank you. Any rebuttal argument, Mr. Boyda?
Briefly, I would note that at page 18 of the transcripts, I'm looking for the specific line here. The officer agrees, and it's lines 2 through 4, that there were 2 people in the woods. So it's in response to my questioning, but at any rate, he admits that there were 2 people in the woods. That's to the extent that people have disputed that.
All right, well, defendants moved to quash the information. The court has to review this on abuse of discretion standard for whether the district court abuses discretion in finding that there was probable cause that the crime of resisting obstructing police was committed and that this defendant is the one that committed it. The issue is whether the defendant knowingly disobeyed the police officer's command to stop while getting foot chased through the woods and whether that command was lawful. I find that there was probable cause that the defendant did commit this crime. He admitted that he was being chased and he heard yelling and seeing a flashlight chasing behind him. His actions in bailing from the car, whether he's the passenger or the driver, at 3 a.m. at a stranger's property in the winter, running into the woods, gives reasonable inference that he knew the police were present and he was seeking to avoid contact with them. So did not abuse his discretion of finding probable cause that the defendant knew it was the police chasing him and ordering him to stop, and he failed to do so. The defendant also raises the issue whether the command to stop was lawful, arguing there was no reasonable suspicion for a Terry stop in that situation. But the behavior of the car's occupants did justify an investigatory stop. And it's always helpful. The Fourth Amendment touchstone is reasonableness. So it's always helpful to put yourself in the shoes of the officer encountering the situation and imagining what we expect them to reasonably do. So just imagine for a minute what might happen if the police ignore that situation. And perhaps then those suspects enter the home of the house that they just are running around by at 3 a.m, but the police just took off. There'd be an outcry. Well, how come the police just left and now left this poor homeowner to deal with this situation? Or it's the middle of the night, in the middle of the winter. What if one of those kids who's probably drunk, and it turns out they were, trips and falls and dies of hypothermia in the woods? Then people would say, what the heck is wrong with the officer for not checking this out? I don't think it's reasonable to say the police, given what they encountered, had to shrug their shoulders and say, that's weird, and drive away. I think they were entitled to investigate the situation. And I think that's justified by the Supreme Court case of Illinois v. Wardlow, 528 U.S. 119 in 2000. There, a suspect's presence in a high crime area, which there was a suspicious situation, coupled with his flight from nearby police, gave rise to reasonable suspicion of criminal activity to justify an investigatory stop. Here, the defendant was present in a suspicious situation, not a high crime area, but a car stopped in the middle of the highway at 3 a.m., just outside a bar, then backing over a snowbank into a driveway. Well, then he fled on foot to avoid police contact. This justified further investigation. And I think a quote from the Wardlow opinion describes how we view these situations through a lens of reasonableness. The Supreme Court said this. In this case, moreover, it was not merely respondents' presence in an area of heavy narcotics trafficking that aroused the officer's suspicion, but his unprovoked flight upon noticing the police.
It's a really good
Our
question.
cases have also recognized that nervous, evasive behavior is a pertinent factor in determining reasonable suspicion. Headlong flight, wherever it occurs, is the consummate act of evasion. It is not necessarily indicative of wrongdoing, but it is certainly suggestive of such. In reviewing the propriety of an officer's conduct, courts do not have available empirical studies dealing with inferences drawn from suspicious behavior, and we cannot reasonably demand scientific certainty from judges or law enforcement officers where none exists. Thus, the determination of reasonable suspicion must be based on common sense judgments and inferences about human behavior. We conclude the officer was justified in suspecting the suspect was involved in criminal activity and therefore investigating further. You know, it's not unlawful to try to avoid contact with the police. I'm not saying that you have to, police officers walking up to you, that you have to walk up and greet them. You can cross the street if you want, but that's a factor for the officer to consider in a fluid environment. And here, 3 a.m, bailing out of a car and taking off in the woods, he has to look into that. Admittedly, as I've said, this might not be the strongest case of resisting obstructing. I'm not sure what a jury would do with that situation. It's pretty clear. I don't see a whole lot there. I don't even know, but I have to be mindful of my role. I'm not the prosecutor. It's not my decision whether to charge the case. I'm also not the district court judge. It's not my decision whether to bind over the case. It's my decision, and I'm not the jury. It's not my decision whether to acquit or convict this defendant. It's my decision today whether the district court abused its discretion in finding probable cause. And here, I just don't think that was present. So these are factual issues for a jury to resolve. The motion to quash should be denied. All right, we also have, looks like a show cause of some failures to test and some missed and late SoberLink tests. Mr. That you're in contempt of court for violating the conditions of your bond, and obtaining a new misdemeanor traffic criminal charge. You have the right to have a hearing on those allegations where your contempt would need to be proven beyond a reasonable doubt. You do have the right to the assistance of Mr. Voida at any such hearing. If I find you to be in contempt, I could jail you for up to 93 days or fine you for up to $7,500 or both.
And I'm no longer muted.
Also, if I believe that you're not complying with the conditions of your bond, I can revoke that bond. Mr. Voida, knowing the rights that he has and the penalties that he could face, do you want this set for a hearing?
Yes, Your Honor. I would note that with regard to the misdemeanor charge, that has been dismissed pursuant to a admission of responsibility to a civil infraction. I don't know that that's going to be in dispute, but nonetheless, we would ask for a hearing on all at this point.
Okay, we could set this, say, for October 9th at 9:40 for a docket call and bond violation hearing.
That sounds good, Judge.
Now, if there's, be in touch with Mr. Razzabon, whether he or you want to proceed to a contested hearing that date, you certainly can, but my intention would be if neither one of you really want to do that, to continue to monitor, see if there's no further violations. We'll just kind of keep this tracking case, and I'd like to not revoke his bond on the matter. So maybe you can consult with your client about what he has to do to comply with these conditions.
I certainly will, Judge. Thank you.
All right, so Mr. Knopf, we'll see you back here October 9th at 9:40 in the morning. Because there have been some issues with compliance on bonds, that will have to be an in-person. Okay, we'll see you then, sir.
Thank you, Judge.
All right.
That's all I have to do this morning.
Okay, have a great day.
There we go. Yeah, that was fun, right? Got reversed, backed into a driveway, missed the driveway, hit a snowbank, got out of the car, right into the woods. Terry versus Ohio all the way. There was no reason the cops should have chased him. No reason whatsoever. Yeah, that was fun. But yeah, Bacon did play that about a month ago. I got the same clip he did. I just didn't play it for a while. All right, next one. I think we visit Judge Boyd now. I think it's Judge Boyd's turn.
Okay, now I'm in an exceptionally good mood. All right.
She's in a good mood. This was recorded on whatever that is. So she got flowers, chocolates, everything from her staff. That's why she's in a good mood. And then she has this guy.
So an offer was tendered. Where are we on this case?
Judge, it's my understanding, Mr. Gonzalez has brought to my attention that his mother is in the process of retaining Tony Gonzalez. Tony.
I feel like my attorney she's helping.
No. So let's time out. Because if you're going to start with, I feel my attorney is, and then say something that is not nice.
I was gonna say nothing like that. I was gonna say I wanna dismiss my counsel and hire a new attorney. Okay.
All right. So today we're here for a plea deadline date.
I'm gonna take it to trial.
I'm sorry.
I'm gonna take it to trial.
Okay. All right. Well, I tell you what we'll do. We're going to recall you back tomorrow for your jury trial. And so whatever attorney you have, you need to let them know that you're going to trial tomorrow. You understand? State, on Rudy Gonzalez, this is an unauthorized use. Should this take 1 day for trial?
I think so, Judge. Can you give me one moment?
Sure. Could I have a reset form, please? I think if we pick a jury, then this should be done fairly quickly. Will Mr. Cox be joining you?
I don't think so.
Okay.
Judge, I don't know if the information that he was providing, I haven't.
I don't even know what's going on. The police, like, I haven't been able to. What's going on with my case?
Oh, well, she's here. You want to speak with her?
May I have a conversation with her?
Sure.
Get back to this, please.
Sure.
Thank you.
He wants to have a conversation with you.
Okay.
And then just approach.
But if I can approach off the record.
All right. So that guy didn't have an attorney. He's in the process of hiring one. And he said he wants to go to trial. So I get that was kind of mean. But that's what he said he wanted to do. I don't know why she said do it tomorrow. I don't know. Maybe she has history with him. I don't know. But I don't think she's mean. I don't think she's mean. Mimi. The next one, we're still in Judge Boyd. You may have seen this one. This one's been out there. I've seen it from at least one channel. I don't know if a bunch of people's channels has it, but I want to know what you guys think. So the first clip is from, I think, a week or two ago, and then his follow-up was today. So I have both his clip last week and the one today.
Chrisman? Yes.
How are you?
All right, where are we on this case?
Your Honor, the last time we were here in court, we were discussing the fact that we still needed a DD 214
Mhm.
in regards to move forward with any type of evaluation that you requested of us for him to potentially move to California.
Mhm.
At that time, Mr. Chrisman told me that his uncle may have had it, his dad. And there's a few family members had it, and you gave him until today to email me that hard copy of a DD 214. I've checked in with it a couple times. as of this morning, I still do not have a copy of the deed to 14. And as of this morning, he also told me he does not have a copy himself.
All right, where is it?
Well, it burned up our 2 years ago, so that's the only copy I had. And I was unable to get it from me and my family. But when we were there last, I know that I did mention to you about getting, doing the, not through them, but through like a different, like private one. And I did find one in California and one here that specializes.
No. Here's my question. My question is, have you turned over the documents to them?
No, I said, no, man.
So-
It's burned in the fire and can't get access to it.
All right, so burned in the fire. So what you're telling me, and if I'm incorrect, just correct me. I'm not going to take it as a sign of disrespect. So what you're telling me, if somebody has been in the military and their documents are burned, it doesn't exist anymore. It's like you were never in the military. Is that what you're telling me?
No,
Once something burns to the ground, the military doesn't have anything and you can't get anything from the military.
well, there's a lot
Yeah,
of
that's how it works.
troops out there that
That's exactly how it
their
works.
benefits and have had issues like this.
No. I'm talking about you specifically. So what you're telling me is, and correct me if I'm wrong, and I ask you this because I will tell you in my family, I would say out of all the male members of my family, only 2 have not been in the military. So what you're telling me is if you have documents from the military and they get burned,
Thank you.
you're just out of luck. These documents don't exist.
Well, I never used benefits, never planned on it, and never needed it. So, to me,
Well, I will tell you
I don't
this.
know how to gain access to it either.
I have a problem with you. I'm being told that you're testing positive for alcohol. So I'm going to help you.
Well, that's why I joined the medical program here, and I found a treatment program in California, especially in alcohol.
Well, I'm going to help you out here. I'm not allowing you to transfer to California until you get me the military documents. So that will help you.
Yes.
And probation, he's going to do 90 sober meetings in 90 days. So if you wish to transfer to California, then you bring me proof that you were in the military.
Yes, ma'am.
You understand?
Yeah.
So until I have that proof, you're not being allowed to transfer.
Okay.
All right, so we'll alter and amend. Do we have a motion to revoke heard on him, Ms. Abrams? Does he need to have the motion heard?
No, Your Honor, it's not one is filed.
All right, so we're gonna alter and amend. You're gonna do 90 sober meetings in 90 days. And you're gonna provide medical proof to probation for your use of oxygen. You understand?
Absolutely.
Probation, when do you want medical documentation of his issues?
At the end of the week, they're
All right. And who are you receiving health care through?
It's through Aetna.
Hmm?
Aetna?
All right. Do you go to the VA or no?
No.
Have you ever been to the VA?
No.
All right. So you're going to have to provide proof of your medical issues to probation by the end of this week. So that's by October 20th. Do you understand?
Yep.
Because my concern is sometimes you have an oxygen tank, sometimes you don't. I don't know what's going on with you. So we're coming back on October 20th, and you need to have that information to probation. And your transfer to California is denied. So if you truly wish to go to California, bring me the military information. And if you do not have military information, or if you were never in the military, let the court know, and I'll consider something else.
Gotta figure out how to get hold of it.
I'm sorry?
Gotta figure out how to get hold of it.
Oh, it's easy. It's government. They will have your documents somewhere.
This is the VA records. Every document. Same place that we're talking about. Go to the VA records and how you work. You'll be in the
Could you all do me a favor? Because I know you all have said you told him where to get his records.
Yes,
ma'am.
Could you
we have-
write something down and
Yes,
hand
ma'am.
it to him?
And there's no record, Your Honor, of him ever serving in the military.
Yeah.
Department.
No, I understand that.
We'll
But
write something down.
Write something down
Yes,
for
ma'am.
him so you will have exactly where you need to go. You understand?
Yes, Your Honor.
Okay.
And we have assisted him in obtaining his records, Your Honor.
All right. Thank you. All right, Ms. Ferguson, Caleb Crum.
All right, I think he comes right back up here in a minute. I believe he does, but I do have the follow-up from today. I didn't see his follow-up on Friday, so I didn't know that it was Friday. So I guess he had a couple follow-ups since then. But I got the one from today. Unless the clip I have is from Friday. I have no idea. I didn't look at the date.
All right.
I should probably
Hello.
go look still.
So your attorney is out ill, and so are other family members. So we're going to give you a reset. All right. What date, Ms. Ferguson?
I think it's
2
right
weeks.
after this. He comes right back up.
All right. Well, we'll see you back on my birthday. Ms. Ferguson will give you a reset form. Okay.
All right, thank you.
You're welcome.
Yes, Your Honor, I understand.
Counsel, has your
editing.
client been able to provide you with the
I am so good at editing.
All right.
Let's see how fast I can find it.
All right. We'll be back on November 9th. So something's going to happen on that date.
Thank you, Judge.
Ms. Abrams, on Angel Montoya, does she need to do anything else?
No, Your Honor.
All right.
I think this is a,
You don't. So that's where we are.
One time, and I ran out last time, because I ran out
Okay.
of.
Counsel?
yes, ma'am.
I'm going to start fast forwarding in a second. I know it comes back up. That's why I left this in here.
That's all to the center.
There we go.
Yes. You wanted to approach Mr. Crispin?
Yes, ma'am. The last time here, you said I could do the other programs enrolling in them, and that would satisfy, everything as well. So, I have one step in California that's an inpatient,
Okay, here's the thing. Take California out of your mind,
and I don't know, because you don't have,
because you're not going to California until I get proof that you were in the military.
well, and what if I can't get the proof?
Then you're not going to California.
So you were saying something about the essay recovery here.
Yeah, to do an outpatient here,
No, inpatient.
well, it doesn't allow me to work or bring any kind of income in.
No, you have
Blue
to
eye
do
makeup, I
inpatient
remember.
if you want to do essay recovery here. It would be so simple for you to get your military documents.
I guess as you're making it to the simplest road, I just don't understand why last time you said it was okay to do it that way, and now you're taking it back, requiring this information.
What I don't understand is why can you not get your military records? What I don't understand is why is Veterans Treatment Court telling me that they have no proof that you were ever in the military? I don't understand this. I don't understand why you're telling me your military paperwork has burned, so therefore there's no, on this planet Earth, nobody has any military documents for you that you were ever in the military. What I'm telling you is, what you're telling me is similar to if my bar card burns to the ground and I can't prove that I'm an attorney. You're telling me there is no government agency
There's
that would have proof that you were in the military.
thousands of troops that can't get their information, can't get
All
benefits.
right.
I
So-
personally never went to the VA, I personally never wanted benefits
Mhm.
or anything like that. Because the way they treat the troops and everything like that, I had my own money.
Okay, so
I
I
worked
want
hard.
you to hear me because I'm internalizing what you're saying. This is what I want you to hear me. You are not going to California until you provide me proof that you've been into the military, and you are to provide them by Friday your medical documentation that you are on oxygen.
That's fine.
And the reason why is because some days you're walking up the stairs, you have no oxygen with you,
But
then
one
other
time
days
I ran out
you
of
don't.
oxygen.
So that's where we are.
One
Last
time I
clip.
ran out last time. 'cause I
It's
ran out of
coming.
oxygen.
All right.
Thanks so much.
So you give me that information, then the court will make a decision on whether or not you can go to California. And I will explain it to you clearly. You want to go to California, you're telling me you have all of these resources there. Or not, because you say you're in the military, but everybody else is telling me you were never in the military.
Then you're telling me that's thousands of troops that can't find their information either and get benefits.
I don't have
Okay.
thousands of troops before me. I just have you.
Well, yes, it's an inherent problem. No, I haven't been
So-
looking for it.
That's where we are.
I just don't understand why you're putting a contingency on that.
Well, I mean, I've told you, I can't tell you anything else. So that's where we are.
So Judge, we omitted conditions for 90 sober support meetings in 90 days and for him to provide medical documentation for the oxygen and so forth by this coming Friday. We have a reset warrant for this Friday.
Yes,
He's coming back here to court
yes,
to provide the DD 214 and the medical documentation. Is
Yes.
that correct? Okay, what would you like, just so that I'm clear
Mhm.
in regards to his in or outpatient treatment? that's
Inpatient
supposed to start here. Okay, and we want to wait until after Friday for that inpatient treatment to begin.
yes.
Okay.
I guess I'll see you Friday. Thank you.
All right, you're welcome.
All right, this isn't the next case. This is the same case. It's just a follow-up. So this is from today.
Okay, let me
He's wearing the
look at
exact
that
same
real
outfit.
quick.
That must be his court jacket. Oh, I guess it's a code. I shouldn't make fun of them. I mean, they are in Texas. And then whoever asked
Sorry
about the
that. Let me.
clip on the thumbnail, that's coming up right after this. This is like 5 minutes long, I think. Look at all her flowers, though. Bye, Pick. Have a good night. If you go live later, I'll stop by. Thank you. I appreciate that. It's very kind.
Okay. So where are we?
Your Honor, the last time we met here, you asked the veteran to provide information claiming his veteran status. Unfortunately, as the felony BTC is concerned, we still do not have a DD-214, a VA card, a service letter, anything at all regarding to any type of military service. I did receive a text message from Mr. Chisholm on Friday explaining that a date of birth might have been put in wrong somewhere within the governmental system. I did follow back up just in case it did occur with the VJO who did the assessment for Mr. Chisholm. I spoke to both of them. They stated that they asked him personally for his date of birth, and when they did go through the DoD records, they're still coming up empty on the fact that there was no military service for anybody under the last four of his social or his date of birth. So unfortunately, as of now, we're still where we're at.
All right. So probation. What are our plans for Mr. Chisholm? Because I don't think the military issue is ever going to be resolved. I know you can look at it online, and I know you all have been online, and it's not there.
Yes, ma'am.
And I know that there was a fire, but the fire he's speaking of is not a fire at the facility that holds the records, correct?
Correct, ma'am. He's speaking about a fire that occurred at his home. I do believe the residence off of, I'm blanking on the address, but the one where you lost your two dogs.
Yeah.
Okay.
So that occurred in a fire at the military facility he did talk about last time. He was too young for his records.
Okay.
Your Honor, so I think one of our major concerns is Mr. Chisholm.
You said it, not me.
Alcohol. So that's our major concern at this point. The original thing was, him to try to get the services to get to where he has a more supportive base, but at this point.
Because here's my concern. I don't like sending, for want of a better word, problems to somebody else. So to me, sending him to California would be sending a problem to California.
Mhm.
I just don't see how that's the answer.
I know the last time we were here, Judge, Mr. Chrisman, did have he did ask about some treatment. So maybe the treatment that he was more leaning to, we can look further into. I know that there was an outpatient treatment and then there was an inpatient treatment.
All right, is there a treatment available for him maybe at Lifetime Recovery?
I can check with Lifetime, see if they have any beds available.
All right, Mr. Chrisman, Lifetime Recovery will be able to help you. I don't like sending what's considered a problem. I don't like farming work off to other people and say, oh, we can't solve this problem, so here you go, good luck to you. And I don't think it will be fair to you or right for me.
California.
Yeah, I don't think it would be fair for me or fair to you to send you off to California. And I don't even have any, much like your military records, I don't even have any documentation from California saying, oh, this is my support staff or supportive group in California. I don't have any of that.
I have it, it's through Concord, and you told me.
It's a good question.
The last time we talked, you were
Yeah.
requiring this one direction.
But I have nothing. Everything that.
That's probably something he's lied about his entire life, and most people believe him. So he just went with it and thought he can get away with it in court. So my guess would be.
So far,
I
everything.
Information today. It's got.
Well, here's the thing. So far, everything that you told me, I don't have any documentation for.
Because we were going down one direction. I do have the information from Concord that I was accepted into an inpatient program in California through Aetna, which is my insurance.
But here's the thing, being accepted and actually being in the program, I don't know if I send you to California, you're actually going to go in the program. That's the issue.
I have to go in the program because then I'm still on probation in California. So they're going to relate it all together. So I
No,
have to go.
that's not the way it works. But if you want to give her that information, you can, and we can come back when we come back. But I want to see if Lifetime Recovery will perhaps accept him.
Yes, Your Honor. I'll check with them, especially with his medical issues. What was the other name? Remember the last time we were here? Oh, San Antonio Recovery. San Antonio Recovery may be another option, Judge.
All right, so we'll look into Lifetime, San Antonio Recovery, and also
Concord.
see about his California, but he has to provide documentation for that. And then it will be up to California whether they even accept you. People think when I say probation is transferred that it's, oh, I wrote transfer and you're there tomorrow. That's not the way it works.
Yeah.
Right. Thank you.
Thank you, Your Honor.
Kind of agree with you there. I think there should have been a little bit of punishment for him lying about being in the service. But I don't know. I'm not a judge. I don't know. Maybe she just wanted to get him in treatment. Who knows? All right. This last case. This is the one that is on the thumbnail. And this one's a little bit of a slow burn, just a heads up. Kind of starts a little slow. But pay attention. Especially when they all watch the police body cam footage in the middle of the hearing. I'm going to warn you, we can't see the police body cam footage, but we can hear it. We can hear it loud and clear, but we can't see it. So before we get into it, one last sympathy ask. If anyone would be willing to donate to Linktree, my demonetization, I can't even talk. It's there. I'd appreciate it. All right. Let's go. Hey, Brenda.
Okay, it's the date and time of sentencing. Dean is here with her attorney, Mr. Johnson, Mr. Rossiter, Ms. Truesdell here for the people. The conviction here is attempted assault of a police officer or resisting, obstructing Have you had a chance to go over this pre-sentence report, ma'am? Is it factually accurate, or are there changes, corrections, or additions to it?
No, it's just accurate.
All right. So then by way of allocution here, Mr. Johnson, are there comments you'd like to make?
Reused
There are,
content.
Your Honor. I think as a starting point, I've had a lot of conversations with Ms. Dean about how she got to this point. And obviously it's clear in the report that she is reflecting back to the original charge, if we had a trial on, where she was found not guilty, that really got the warrant out and then started this process. That being said, I don't think that really had as much to do with this as she thinks it does. I think it's really her mental health as well as her perception of the purpose and validity of law enforcement. So what I've done is had several conversations with
One and the
her,
same.
First about mental health, and I won't bog the court down with it, but she is seeing mental health help. She is getting help. She's got her medications reviewed. She's doing the things that she needs to do to make sure that she is mentally in the best shape to deal with any sort of triggers or any bad situations or anything that might come up. But two is just an understanding of what law enforcement's role is here. The officer on this date did not want to have to remove her from a vehicle, did not want to have to arrest somebody on a warrant, did not want to have to pull over a vehicle, didn't want to have to do any of those things, but that's his job. And Victoria, you understand at this point that police have a job, they have a purpose, and there's a reason that they're there. And that, yes, there may be these outlier cases and bad things certainly can happen, but by and large, they're to fulfill a very important purpose in society. You understand that now? So I think, if she has any contact with police, and I think she's had conversations with police since then, she had a conversation and she's going to talk about this sort of shortly after this happened, where, she got
January
to talk to an
10th.
officer and saw that they're not out to hurt her. They're not out to beat her or kill her or anything like that. And so long as I think she's properly taking medication, has her mental health, properly under review, that she's seeing somebody, I just don't see something like this happening again, because I think her fear throughout this case, you can feel it. This has really stressed her out. And that being said, that's not an excuse for obviously what she put the officer through on this date. So I know that she is apologetic. I know that she has changed the way that she's thinking about this. So, Your Honor, I think that the recommendations are appropriate. I think keeping an eye on her during probation, I think is certainly appropriate, but I do think that she's going to be successful. I think she can be successful, and I think she wants to be successful. Regarding sort of, just to touch a little bit on some of the relationships that were brought about in the trial, I think she recognizes who's good to have in her life and who isn't, who has her best interest and who doesn't. If you have bad relationships with people, just stay away from them. There's no reason. It's a big enough area that you don't need to have contact with people you don't need to have contact with. So
thanks, buddy. I appreciate it. I just saw it.
Asking for the court to file the recommendations, but I know Ms. Dean didn't want to address the court as well.
Okay, thank you, Mr. Johnson. Ms. Dean, are there comments you'd like to make?
Okay, the reason why I had an issue with officers is because years ago, my cousin was shot and killed by a federal agent in the chest at 23, and it shocked me and to the core. It started PTSD, and every officer now is gonna shoot and kill me. That's why I acted the way I did towards the officer. In the video of this cam, Kayla was there with me, my friend, and she was telling the officer that I'm having a panic attack.
We get to hear it,
I
though.
get on the phone with my parents, and they were, also trying to tell me to calm down because it's going to make it worse. The stay in the police or the jail helped me immensely because it showed me that every officer is not going to shoot you, not going to kill you. They're here to do a job, their job. And, I know now that every officer, I did have an encounter with that particular officer when I was released. He was around Mansalona and we were walking around and he asked if we seen a perpetrator dressed in these clothes. I answered him, no, just normal conversation like we would do, so I learned a lot from that whole situation. I wanted to let you know that, and I'm trying to move forward. And I have seen mental health 3 times since I've been in jail or to, you know, and then I see her on Friday again. So I'll continue to.
So I wanted to ask about that. That's Life's Works Clinic. Where's that?
In Kilgasca.
Okay, so what kind of mental health therapy is that?
Counselor of some kind. Her name is Laura. I don't know exactly, but it's Laura. I talked to her, Gifford or something like that. Gifford.
Okay.
The guy on the next case.
So, well,
he has no part of
what you're
this.
telling me is true. I mean, it sounds like you're learning that police are there to help you, not to cause harm to you or to harass you or anything like that. And you were completely out of control with the police. And
I was because. Okay. Yes. Yes, I was.
all right. All right. So, Ms. Truesdell, anything, or Mr. Rossiter?
I'm not quite sure what to think of what Ms. Dean is saying.
I'm glad you made it too.
I'm looking at the PSI, and so this is all after the fact. Defendant's statement. The defendant stated this case originally found an 8-year-old child lied on the stand about assault charges. That's a mighty bold statement. There is a difference between lying and a jury finding that there's not proof beyond a reasonable doubt. There is an absolute distinction between the two. And that's
Not a
one
bull.
reason.
I just
It's
didn't do
difficult
anything
to
with
put
it.
young children on the stand. Because if the jury doesn't believe them, quite often the children think, well, why do they think I lied? Well, maybe now I have my answer. Because defendants like Miss Dean say they lied. She said, and this isn't, she thought, she thinks all law enforcement officers will kill her because her cousin was killed. I want the court, I've got the video of this incident, and I think the court needs to see
You will in a second.
how out of control and inaccurate she was. She was absolutely obnoxious. She was the only one. The next statement I want to point out.
It's not a bull.
The
It's just
defendant
lie.
did state she blames, not blamed, blames current, blames the state of Michigan and Antrim County for this case. She also continued to blame the victim in the other case. Regardless of the outcome of the trial of the assault, the reason she was arrested on this instance is because she did not appear in court. That's what the bench warrant was for, failure to appear. She parlayed a 2021 assault and battery into a 2023 R&O. Not many people can do that. She says that she thinks all police officers are going to kill her. I'm not sure when this incident she's referring to and why it happened, but this isn't the first time Miss Dean has been arrested. She's been arrested, going back to 2016 or 2017. And in spite of all that, I just can't fathom that somebody needs to be 41 years old to realize that the police aren't out there shooting everybody. So I don't believe much of what she said about I've learned from this. I think what it is I was completely out of control. It's traffic stop. Now I will say anything to get myself out of a hole. So if I make trouble so that the court can view, and I've got the whole stop, but I'm starting from the point where Deputy Bradley tells her that she has a bench warrant. And then I think it's instructive because, quite frankly, 12 days for credit for time served. When she is on the phone saying, "Mom, he has his hand on his gun," that's the kind of stuff that gets spread around And as Winston Churchill said, a lie gets halfway around the world before the truth gets its pants on. And you can laugh all you want, Miss Dean.
Ms. Dean, don't laugh.
It's just the way about
Don't,
it.
don't
Pam's.
laugh. Be quiet.
Get it.
Prosecutor speaking.
That's how fast things spread in today's day and age. And it's compounded by the fact that nobody wants to take personal responsibility. So if I may approach the court.
Sure. Mr. Johnson, you've probably seen this. But
Here we go.
come on up. Come down there.
It is good. I appreciate everybody watching this. I feel like I can't talk tonight. Okay, again, we're not going to be able to see this
Ma'am, I'm
video,
assuming you've seen this,
I
right?
have not.
but we
Well.
sure as hell can hear it.
Mr. Johnson, come on up. Can you make that brighter? Or is it
No,
time of
that's,
day?
I'll step
I
back.
gotta go over and talk to Victoria. Yeah,
I'll tilt it this way.
so Victoria, go ahead and undo your seatbelt and step out. You got a warrant for arrest. Yeah, you got a criminal bench warrant. Yeah, you got a criminal bench warrant. I'll explain it to you. She's got a criminal bench warrant. I'll explain it to her when she gets back to my car. No? Hold on. So it's failure to appear. What's that? Yeah, yeah, and this is the ID that you gave me, correct? I just ran it, and you got a bench warrant out of Antrim County. What's that? What's that? Well, so she was gonna legally. So she was gonna legally drive the vehicle, so I had. Okay. Well, okay. She told me she was gonna drive the vehicle, so if you want to hang out over there, because if you want to drive the vehicle after it, because Kayla's not gonna be able to drive it, so. Affirmative. The ops is David 500-847-465-547. Go ahead and send another car this way also. Okay. I hate pigs! What are you having? They killed Colin, and this motherfucker's gonna kill me too, Mom! No, Victoria. He's gonna kill me! He's gonna go for his gun, what? Victoria. He's gonna kill me! Victoria, I don't even have my hand on my gun, so don't. This fucking pig right here! He's gonna shoot me! Just like they was gonna do to you! This fucker! Victoria? I don't know! You talk to him! This is my dad! Here, you talk to him! Victoria, I don't have to talk to your dad. They're gonna arrest me, Dad! You ever... I didn't do shit! I didn't do nothing! Victoria? I didn't do nothing, Dad! This pig is gonna... Victoria, you got a criminal bench warrant. I have a criminal bench warrant, Dad! For what? Dispatch is checking it. He don't want to talk to nobody. He said no. Central 28, confirm that warrant. Dad, I can't fucking do it, this shit. I can't fucking do it. Take me to the mental institution and take me to jail. Call the fucking police. Call the cop, please. Call the fucking ambulance, please, Kayla. Here, she's gonna call the ambulance. Call 911, please. Said turn around, put your arm behind your back. Arms behind your back. I asked you nicely once. You have a bench warrant for your arrest.
No, it's alcohol, I think.
Please, get my phone. Record it. Hey, Victoria, quit. Please call her. Quit. It hurts. You're hurting me. What's that? Yes. Hurting me. You're hurting me. Victoria, quit. I have sciatica. Okay. And fucking faulty dishes. Please. Okay. Call my mom. Call my mom. Okay. Victoria. Seven more times. He's hurting me. God damn, this fucking pig is hurting me. God damn, please. Victoria. Hey. Stop. Leave me alone. Get your hands off me. Get your fucking hands off me. Call her. Seven, please call her. Record this fucker. Please record this fucker. Please. Steven, help me. She's got a warrant. Steven! Out of our county. Steven! There's no bond. Steven, please help me. Yes. She has to wait to see him then straight tomorrow morning. I can't do it. Call my mom. Call my mom, please. Yes, yes. Mom! Mom! This pig is fucking with me! This fucking pig! Okay, like get her shoes for her. Please, let me see my mom. Mom! Mom! He's arrested me. He's got his hands all under me. He's touching me. And the fucking handcuffs are so tight. I can't. I want the mental. They need to call the ambulance, please. Call the ambulance, Mom. He has his hands on me. He's restricting me. Please. Mom, call the ambulance. Okay. I want an ambulance. Victoria, stand up. No. Okay. Victoria, you make this a lot easier. Get your hands off of me. Get your hands off of me. Please stop. Okay. Mom, help me. Victoria. Help me, Mom. Hey. No, help me. Victoria. Victoria, I'm going to explain this to you. So, he has his hands on me and it hurts. Victoria. Would you please help me, Mom? Victoria. His hands are hurting me. Victoria. He's hurting me. He's hurting me. Victoria. No. So, ma'am, your daughter has a bench warrant for arrest. He has his hands on me. He won't stop touching me. She resisted. I did not. I did not, you faggot. So, if she continues to resist, she's going to pick up a resisting and obstructing charge. Oh my God. 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 Mom, help me. Mom, help me. I should have never came here. Please help me. This is because of Musty lied. This is why. It's because of Musty lied. Okay. Can I go sit in your car? Tomorrow. I can't. I can't do this again. My hands are bruised. He's bruising me. He's bruising me. He's fucking bruising me. Victoria, this is all a recording. So, I don't give a fuck what it is, pig. Shut the fuck up, faggot. Okay. Stand up and go in my car. I'm done chilling with you.
Well,
goes on the whole ride.
Okay.
Yeah, she's much calmer then, but still maintains the same.
I don't care. Bring it to the jail.
Police are going to kill everybody.
I thought I read in the PSI that
Yeah, you're gonna sit in there.
she tried to get out of the back seat or something,
No,
but
you're not.
I think
I
this
asked
is
you to
enough.
cooperate and you wouldn't cooperate.
All right. I didn't want to pause it all during that because I wanted it to be completely together for anyone that's rewatching this later. But wow. Right? I do wish we could see it. I think they say what her name was. I don't know. If someone could grab that body cam footage, I know there are people looking for it. But that crazy. But she got arrested. She had a warrant out for arrest for a failure to appear on a felony, I think. She has 0 bond hold. But I don't know why I feel like alcohol was involved. I think they said that she had, I don't know. I might be wrong on that. I don't know.
All right, so Ms. Jean, what are your thoughts on your actions on this day that you've just observed on the video?
I have so much PTSD and anguish and stuff from my cousin being killed and in Traverse City.
When did that happen?
I don't recall. I think it was the 2000s. It really was like 2016, in fact. Okay, but my dad
If she's 24, she's been smoking since she was 4.
deal with, the Grand Traverse. And I'm telling you that because one of the bailiffs was going like this to my dad. And that's what I'm referring to about going for your gun, but this is not here nor there because I acted a fool, obviously, and I already knew that and seen that.
Were you intoxicated or on drugs or anything?
Nope, nothing.
I was wrong. I don't know why I thought alcohol had something to do with it.
It's just my mental status right now is very much so just all over the place. My own family stole from me. I think that has a little bit to do with it, I don't know. My mental status is not okay. It is
How the
way better
fuck
now
would that have
because of
anything to do with it?
dealing with it, getting help, taking medications.
So when did you decide to go to Life's Works Clinic?
It had to be like 2 months ago now because once I was having this trouble with the trial and everything, I needed help. So I reached out for it. So I've been talking to her for quite some time now.
Your Honor, if I could provide a little information, the offense date was 8/12/23.
Right.
My admission date for her going to Kalkaska, which initiated counseling and other services, is 8/24, which I believe is the day after she got out after sitting those 12 days.
Did you let the counselor know about this incident and how you acted?
We didn't go any further, like a lot, but no.
After seeing that, do you think you have something else you want to maybe talk to your counselor about?
Sure, absolutely.
Your conduct was just unexcusable. Mr. Johnson, anything you'd like to add here?
Your Honor, it absolutely is inexcusable, but I really do think that goes to her mental state. And I think that should be the goal of this probation, is making sure that she continues in that counseling, that she continues going to that she continues following medication reviews. This isn't going to get better unless she is active in trying to make this better, because she recognizes that they're not allowed to kill her. They had a valid warrant. The warrant was because she failed to appear on a prior case. And she even admitted in the video that she knew that was the reason that she had a warrant out there. So I think, I recognize that the court may give her somewhat of a shorter leash here, but I would be asking that we oversee her continuing to go to treatment. I have noticed just in the 3 months that there is a difference, I couldn't talk to her at first, and now I can talk to her. I can have a conversation with her. She understands what's going on. I think she needs to continue down that path, and I think if she doesn't, she has to understand that this is a felony. She could very easily be charged with a felony if any conduct even close to this occurs in the future. And based on the roster statement, I don't think they're going to be so gracious with a misdemeanor offer at that point in time. So she's got a decision to make: get better or go to jail. And unfortunately, those are the options right now.
Mr. Rossiter, anything further for the people?
Just like to point out here, I think it would be interesting to know, because the underlying charge that was the basis for for the bench warrant, the assault and battery. Because it was an assault, I didn't issue a criminal summons. I issued a complaint and a warrant. I would like to know if she was arrested on that warrant because she was arraigned. And when a warrant's issued, you get arrested.
She had gone through the process. She failed to appear at the final conference.
But you get to a final conference after an arraignment. You get an arraignment after you have either been served a summons
or
been
arrested.
and turned yourself in.
Were you arrested on the assault and battery charge?
I thought it was, that was why he arrested me. That's why I had a warrant out for my arrest, so that's what he was telling me that I had. So I don't understand the question.
I don't know that history.
He's waiting for his case. He's up next.
I let you know, the only other thing that I had was the few years ago, it was retail fraud, and I already had, we discussed that, you know. That's what he was bringing up, that I've been in trouble, but it was years ago when I was young.
No, so was there an arrest warrant for the assault and battery that the officer was arresting her on at this time, or she failed? Was there an arrest warrant and she failed to appear for arraignment?
Yeah. She was arraigned on September 14th, 2021 by Zoom. So she was arraigned on an assault charge.
Okay.
Prior to that arraignment, I did not issue a summons. I issued a complaint and warrant. So she didn't turn herself in. She was arrested.
Okay. So you're there too, you're ignoring court orders, you're ignoring police and authority.
I'm just confused on it because we were in court multiple times.
My point for pointing out the possibility of an arrest in 2021 is if she didn't have that response then, why is it now?
So, Ms. Seabird,
I'm looking at the assault and battery case right now in our system, Your Honor. In the ROA, it doesn't show that there was an open warrant ever issued. There was a notice for an arraignment mailed, and then the defendant called the court wondering what this was.
That could be from the time of COVID when those things were optional.
all right. Well, okay, so I do believe that there must be a mental health component to this. There's no explanation for you reacting the way you did with the police officer, just not. And you weren't arrested on the assault and battery, so we don't know how you would have reacted back then. But I think there is a mental health component here. But I also think given the way you acted toward the police, there should be a jail component here too. I mean, that seriously put everybody at risk by the way you acted.
I was jailed for 11 days for that, I thought.
12 days.
Right. I served 12.
All right, but I think some more should be ordered. So probation's going to be 1 year, $100 fine, $500 court cost, $75 crime victims fee, $50 state fee. Again, is a felony, so there's a $700 attorney fee. While on probation, you may not consume or possess alcohol, may not use or possess illegal drugs or mood-altering substances, no recreational marijuana, not to consume or possess non-prescribed medications, not to reside where alcohol, illegal drugs, firearms, or weapons are present, not to be in possession of any firearms or other weapons, not to behave in a violent, threatening, intimidating, harassing way toward anyone, be respectful of all court employees, service and care providers, may not leave the state without the consent of the court. Now, I don't know anything about Life's Works Clinic, but I'll order you continue treatment there, follow the recommendations, but I'm going to have probation also determine whether a mental health evaluation beyond what you're doing there is necessary. It seems like maybe it would be discretionary drug and alcohol tests. Let me make sure I've included everything here. All right. So the jail is going to be 45 days, credit for time served, notify probation if you have any contact with law enforcement on probation. So if you don't follow the terms of this probation, you still have a year or less credit for time served that you can do, okay? So take advantage of this probation, do well in your mental health therapy, because it's clear you need that. We'll see where things go, all right? So you're all set for now, so go ahead and have a seat over there. All right.
That's it. That was it. Slap on the wrist. They said 45 days credit for time served, though. Did she spend 45 days in jail? So I don't know. But yeah, the person in the orange, I saw a couple people ask that. That was just the guy waiting for the next case. He had nothing to do with that case. Yeah, it'd be awesome to get my hands on, or anyone get their hands on, not just me, anyone get their hands on that police cam footage. That would be awesome. But yeah, that's all I got. Thank you all for coming. I think people in court might be going live. Not exactly sure. I just saw a Discord message that asked if she should or shouldn't go, so she might be going live. If she does, it'll be in the next 10 minutes, so we can all jump over there, hang out there if you want to. But yeah, I really appreciate you guys coming. If you haven't already, make sure you hit the like and subscribe button. Do your jump kick, backflips. Donate to my Demonetization Fund. All the fun stuff you should be doing on a daily. I can't. I'm getting too used to saying that I don't like it. All right. I'm out. I'll catch you guys next time. Bye. I completely forgot to thank for the super chats. I'm back. I know I just lost a lot of people, but I was writing them down so I didn't keep stopping the video as they came in. So I want to thank Rich and Hayden Harris for the $5. That was awesome. Got Peter for the 23, and then Tom for the 15. I appreciate it, guys. I almost missed saying that, but I didn't. All right, now bye.